Yes, Mr.
Malad, 23rd August 2010, NCT published a notification in exercise of the powers conferred under Section 23, subsection 1 of the Right to Education Act 2009, thereby prescribing minimum qualification for recruitment as a teacher in class 1 to class 8. That's Millard 124 of the convenience 187. Then Millard 12th November, 12th November 2014, in exercise of the powers conferred under Section 332(2)(dd), read with Section 12A of the NCT Act 1993, NCT published a notification, namely National Council of Teachers Education Determination Minimum Qualification of persons to be recruited as education teacher and physical education, prescribing in primary, upper primary, secondary and secondary education so and so regulation. To this regulation inter alia prescribe minimum academic and professional qualification required for being appointed as a primary teacher. Regulation 5 provides NCT the power to relax any of the provisions of the at the request of a concerned state government, save and except the regulation with regard to the minimum qualification for appointment of teachers for class 1 to class 8. This is very important for our case. Because point was taken by the one of the point that the repetitions that qualified, non-qualified, okay, trained and untrained. I will come to that. This is Millard annexed to S and so. 9th April 2015, Additional Secretary, Ministry of Human Resource and Development, Government of India, in exercise of the power conferred under Section 23, subsection 2 of the Right to Education Act 2009, extended the relaxation to the state of West Bengal in respect of a minimum teacher qualification norms by the NCT till 31st March 2016. That your lordships kindly take volume 1, page 92.
Yes.
This is the 9th April 2015 letter, extension of relaxation to the state of West Bengal under Section 23, subsection 2 of the RT Act 2009 for the appointment of teachers up to 31st March 2016. Lordships kindly come to, I just go to the very relevant portion, kindly come to Millard, page Millard, page 95 bottom. Now, therefore, in exercise of the power conferred by subsection 2(7), clause 7 of section 23 of RT Act, the central government hereby extend the relaxation to the state of West Bengal in respect of the minimum teachers qualification norms notified by the NCT as published in the Gazette of the India so and so 25th August 2010, in so far as they relates to class 1 to 8 as under 2 years, 1 year bachelor's so and so. Important part is the aforementioned relaxation shall be valid up to 31st March 2016 and shall be subject to the following conditions, namely. Why I am showing, my lord, in this, unfortunately, the learned single judge has overlooked all the notification, and unfortunately, the board did not place all these documents before the learned trial court.
I didn't follow, Mr. Wanda. What you said now, therefore, clause
relaxation has been granted up to 31st March 2016.
Where do we get it?
Page 96.
Yes.
Next, Millard, kindly come to list of dates. The relaxation were there. Then Millard, 26 June 2015, West Bengal Board of Primary Education published an advertisement notifying the date of making application of TET 2014. It was further notified in the advertisement that a TET 2014 examination would be held on 30th August 2015.
Where you are reading?
List of dates, page.
List
page
of
3.
dates, which date?
Page 3, 26 June 2015.
26 June is not in our page.
Sorry, my lord, I am very sorry. Sorry, my lord. Sorry, that has been. Anyway, Millard, that's not there, I says. 3, Millard, 14 July, this is not very relevant here. 14 July
What
2015.
was the relaxation, Mr. Ward?
Relaxation that even you have a TET, you can appear in an examination, but you have to obtain the qualification of DLT, DLLT within the period specified there. And Lord, that is the crux of the matter here. That is the crux of the matter. The learned single judge has not followed this. I will show. Learned single judge has stated, we are untrained, therefore we could not have applied. Our application should not have been entertained. Our appointment, our selection was bad. I'm coming. I will make it very clear when I'll be pressing these documents.
So you are apropos Mr. Dotto, na?
No. The unfortunate part is
No. You are.
yes. But additional. I used to clarify all that things.
Yes.
2nd March 2016. West Bengal primary school teachers recruitment rules were notified after considering all the objection. So and so. 14th September. TET result. That's our TET result have been declared. 14th September 2016. That is our TET result, and also the writ petitioner's state results have been declared. Now, Millard, kindly come. 14th September 2016. This is very important, Millard. The Honorable High Court at Calcutta in WPA 14548W of 2016, Chinmoy Dolui and another versus Union of India, reported in 2016 SCC Online Calcutta 4960, permitted the state of West Bengal to appoint untrained candidates as assistant teachers in primary school even after the period of 31st March 2016. Paragraph 24(1), subparagraph of the word of judgment is good. The notification dated 1st April 2015 was in force up to 31st March 2016 within the said specified period, and the selection process would not be carried out due to the general election being published for the state assembly election. Under this circumstance, if this court permits the respondents in order to complete the selection process, the characteristics and objects of the students will not be jeopardized. The judgment and order for state service, this has not been appealed against. Then, Millard, this is important. Millard, West Bengal Board of Primary Education read a memo number so and so. Invite applications. And let me take your lordships to the advertisement itself. Kindly come to page 117 and 118 of my paper book. Millard, kindly take these two copies, maybe not legible. Kindly see. This is very important for our case. And this is the point. Exactly, this is the point have been missed by the learned single judge. 170. May I read?
Yes.
In continuation of our notice number so and so dated 24th September 2016, this is notified further to all concerned that online applications are invited from TET 2004 for qualified candidates of West Bengal seeking appointment to the post of assistant teachers of a particular council only in the government-aided sponsored primary junior basic school under the district primary school council primary school to the 42,949 vacancy. Kindly see the mark the vacancy. As mentioned below, the selection and appointment of the candidates will be made in terms of the West Bengal Primary Teachers Education Rules 2016 as amended up to so and so. Now, let qualification part. The citizens of India on such other nomination as are declared eligible for government of India has completed the age of 18 years as on 1st day of January of the year of advertisement and has not completed the age of 40 years on the 1st day of January and of the year of higher secondary so and so, graduation irrespective of the marks obtained therein with at least 50% marks and and 2-year diploma in elementary education by whatever name known and qualified TET ability to read. Therefore, this part is showing that the qualification and 2 years diploma in elementary education. Then kindly read note 1. The persons qualified TET and having qualification of higher secondary pass under the West Bengal Council with at least 50% marks or graduate irrespective of marks obtained therein without 2-year, can you read it? Without 2-year diploma in elementary education by whatever never known in accordance with the National Council for Teachers so and so are also eligible to apply for appointment of primary school teacher in the state, subject to condition that those who will be appointed without professional qualification shall acquire the professional qualification within a period of 2 years from the year of appointment. Milord, this is a very important part of this matter. And that this argument, Milord, if I am right, this argument will establishes the judgment, reasoning of the judgment of the learned single judge was contrary to the Milord, the advertisement notice itself. What it speaks about, the relaxation, if you don't have the 2 years, this diploma in elementary education, you can make an application. If you make an application and you are appointed, Milord, this is very important word, if you are appointed. If you are appointed, you are giving a chance to complete the course within 2 years.
Yes.
Distinction in this case is, my lord,
Yes.
we were not having the 2 years diploma course at the relevant point of time when the application was made. Neither we were not the petitioners, right? But we were appointed.
On the basis of such relaxation.
On the basis of?
Such
No, relaxation. We were appointed with a condition 2 years have been. That we have fulfilled, I will show to it. But they were not appointed, therefore they were not entitled to be enjoyed this clause.
Yes.
This is the basic distinction of the matter itself. The learned single judge has gone on a reading that all are not 2 years course are having, therefore they are disqualified. But the note 1 speaks that those who are appointed, they will get the chance to complete it within 2 years.
Yes.
But not in their cases it is applicable because they were not appointed. Then Milord, kindly come. 30th September 2016 to 7th October, that the applicants sharing the read period so and so more than 1 lakh intending candidates made applications pursuant to the said notification dated 26 September. My lord, কোনটা দেখ পড়ছিলাম পেজ 5 তো না কোনটা?
Yes. 30th September. 26th September.
30th September 9.
Yes.
That the appellant sharing the read petition respondent number 1 to 140 and more than 1 lakh intending candidates made application pursuant to the said notification dated 26 September 2016 for appointments to the post of assistant teachers in primary school. The present appellants respondent 1 to so and so and other nearly 1 lakh applicants at the time of making the application were untrained. I am reading from the here because all these averments in the all these petitions are there. I am not taking that time, Milord. Then 12th October 2016, West Bengal Board of Primary Education notified that the scrutiny, verification of testimonials and viva voce interview and aptitude test in connection with 2016 selection process would be undertaken between 19th October 2016 to 28th October 2016. It was notified that the date, time and venue of scrutiny and verification of testimonials and viva voce interview and aptitude test of a particular district. My lord, if your lordships kindly note it. Kindly mark it and note it.
Yes.
This is a very important thing, district-wise selection, not West Bengal basis selection, where the learned single judge has gone. District-wise selection. Website of and the candidates will also be notified about such details through SMS and emails. The applicants therein called for scrutiny, verification, and interviews aptitude test to be conducted by the West Bengal primary education on different dates at different places. I have given the annex here. Some examples I have given. Shall I show to your lordships or that's not required? Then Milord, kindly February 2017. Applicants were given appointment as assistant teacher on probation for 2 years from the date of joining by their respective district primary council. Kindly similar everywhere, respective primary council, district-wise primary council. Respective primary council, district-wise primary council. Now, it was mentioned in the said appointment letters of the petitioners that their service will be regulated by the relevant government rules, so and so, subject to verification of the credentials. Annexure Swan Millard, annexure, it is annexure there. I am not reading Millard, I am just Swan reading. Now, Millard, 31st August 2016. This I will take your to Lordship, Millard. Earlier, I have shown to your Lordship one relaxation. Now, kindly see, this is the relaxation is applicable in our case, Millard. That is at Millard, volume 3 at page 663 to 666 of the paper book. These are the points, these are the circulars have missed. Third August 2017, 663. My lord has got it. Volume 3, my lord. Volume 3 take to you, just okay.
Yes.
My lord, 663 kindly come. This is regarding training of untrained in service elementary teachers in the government aided so and so private. It applies that the amendments to so and so of the RT Act to extend the period for such training to 31st March 2019 has been passed by the Parliament. Therefore, this is not pure, my lord, by the administrative order or notification, but by reason of an amendment in the Act itself passed by the Parliament. Now, my lord, kindly see. 3. A board strategy to complete the training of all such in-service untrained teachers by 31st March 2019 is proposed by MHRD. The following action is required to be initiated urgency at your end. 1, 2, 3. Kindly come to Millard, page 665. Page 665. The timelines along with the key milestones to ensure that the training of in-service untrained teachers is completed by 31st March 2019 are detailed in the table below. Therefore, today, Millard, that time, kindly see, these untrained service teachers who are appointed, they were statutory right has been given to them to complete training within 31st March 2019. Not by an administrative order, not by anything. By amendment of the Act itself by the Parliament.
Amendment to which act? This is
You kindly see this at the top.
RTI.
Yes, right to Education Act. These are because of Right to Education Act. Section 23, no? Section 23, subsection 2.
Yes.
And on that day, I know when the act was passed, I made my debate on that, why it was necessary. 665, 4.
No, this was on 3rd August 2017.
3rd August 2017. By that, it has been extended up to 31st
Right,
March
we
2009.
understand. Now you placed before us this note 1. That is, you just now placed before us note 1.
Yes, note 1, kindly see.
That 2 years.
2 years.
That is 2016 memo.
Appointment, from the date of appointment.
Oh, from the date of appointment. That
Yes.
was in 17.
17.
2 years.
19.
Now, this the Right to Education Act that is been referred to in this notification, which
Yes, this notification because of the amendment of the see page 663.
600. No, this notification.
No. It is not there. I am telling about the laws.
Yes.
I am telling about the laws. Effectively, my lord, when this notification was made, That time, earlier notification was there.
Now, are they disputing that you were not entitled to this relaxation? Is the court saying that you were not?
Court is saying,
Court has what finding has been written?
court has given, I will show to you,
Yeah.
take it from me now. Court has said they are untrained. We
Court
are
has-
also untrained.
Yes,
We are
court
not
has said
qualified.
both the groups are untrained. When they have been given, you have not been given. You have been ousted on the basis of a faulty aptitude test. This was the
This is the case. Therefore, I have given because
But
I
on
was appointed.
on the ground of relaxation, it was not turned down.
The court has not taken note of the relaxation even. Court has not taken the note of the condition of the advertisement even.
All right, all right.
My point is the learned single judge has not taken note of the advertisement.
Yes.
Learned single judge has not taken note of any of the notification.
Yes.
Let me put the point in this way. Learned trial single judge has committed an error by not applying his mind that even an untrained teacher, untrained person can make an application, and if he is appointed within 2 years, he has to get the. This is the
You
distinction.
will show us when you come to the
Aye.
order. Yes. Now,
This part has gone 2019. Done, Millard. March 2019. Come to 14.
March 2000.
Appellants appeared in the examination of the second term of their diploma in elementary education. By 31st March, I have applied exercise. Results have come later. Appellants received the final mark sheet and certificates after 22nd May 2019. November 2019, appellants, upon completion of the DLED course, were granted the training benefits by their respective district primary school. Appellants' pay category was changed from the B category scale to the A category scale. The moment I got this qualification, I am entitled to get the higher grade, and I was given to that grade. Kindly come to Millard, page 647, volume 3. My Lord Justice Chakraborty, kindly remember that there are so many litigations were there in the education group that we have become trained. Our benefits have not given. Court has passed so many orders. 660, 600? 647. See, the following 18 teachers of Swardas Swanso, kindly see, my lord. This is a West Circle under Hooghly district. I said about district. Primary School Council have completed 2 years DLD course on 1 year PD Swanso, 6 months special in service training course. Hence, the training benefit is hereby allowed in favor of them. Here, serial number 4 is one of the appellant here.
Yes.
After completion, I have got it. Then, Millard, December 2019, serial number 17.
Yes.
After satisfactory completion of 2 years service, the service of the appellants were confirmed by their respective district primary school council with effect from 2 years after their respective dates of joining. But this is also in the therefore, Millard, appointment probationary, obtaining DLED course, then training, then Millard confirmation up to 2019. No one is aware about this.
Yes.
2016 selection, 2017 appointment, 2018, 2019, permanent confirmation, everything. No one is aware.
That is why you are here.
No.
Yes.
Millard, I am coming to an argument. Possibly your lordships are not required to hear the petitions at all. Set aside and send it back. Wait for a few minutes.
Set
Set
aside.
aside this judgment and send it back to the single judge to hear the matter again. In complete violation of a natural justice, I will show to that.
Yes, yes.
May not be your lordships are required to take so much.
Yes.
if it is appealed to your lordships.
Yes, Mr.
Now, after satisfactory to a Swantamulak conference, now come 10 December 2019, a batch of writ petition.
Yes.
A batch of writ petition of Swanso versus State of West Bengal are reported were moved before the learned single judge of the Calcutta High Court, challenging the 2016 selection process, same selection process, on several grounds. The Honorable Justice O.D. Banerjee dismissed the said writ petition on the grounds of delay, laches, and also held that since successful candidates like the appellants herein were not made parties in the writ petitioners, therefore, in the absence of successful candidates, the writ petitions cannot be heard at the distant date, and the selection of 2016 cannot be disturbed. I will read the judgment later on. Just keep it your lordship's mind that the first in 2009 selection process, which were challenged by the batch of the writ petitioners, were dismissed on 2 counts. One of the count,
Yes, yes.
delay, another count is not made parties. Now today, why my first forum has gone? You have not made me party in the writ petition. I have to come to live to appeal. Going to Supreme Court has set aside the order and send it to back.
That is there in this list of dates, Mr.
Pardon me?
That is there in this list of dates. Ultimately, you preferred special leave petition.
Not against this order.
You preferred special leave petition against the order.
Order passed in this proceeding, your proceeding which is pending before your lordships.
Please tell us on which date you went to.
I will show. Well, Supreme Court I will show. Now, therefore, first lordship kindly see.
Delay, non-addition of party, relaxation. Got it. Now next.
Now, therefore, kindly just one of the judge has delivered a judgment.
Yes. It was shown to us.
Was it binding to the coordinate bench?
Was it placed?
Placed or not placed? I was not party. I was not party. Whether the board has placed it or not placed. If huh? Okay. No. Single bench এর কাছে কিসের উপর তো প্লেস করছে
না
My lord, I have been told the learned advocate general appeared before the single judge and placed the judgment of Justice O.D. Banerjee. But unfortunately, the learned single judge has not not a single judgment has been recorded and said these are the niceties of the law. I am not required to go to the niceties of the law.
Yes, that has. We have seen that, Mr. Yes.
Our first judgment. I will read it the judgment later. Next. 12th September 2023. WPA 21187-2022 was filed inter alia praying for the disclosure of marks obtained by non-trained candidates and praying for the recruitment of the writ petitioner. The writ petitioner did not seek cancellation of the appointment of the successful candidate appointment, appellants nor any successful candidate. This is the writ petition, which your lordships and appeal your lordship is hearing. Therefore, 2017 to 2022, one of the single judge has dismissed. You are coming in 2022 without disclosing the single judge has dismissed.
Yes.
And if I am right, I will check it up because some of the counsels were common.
Yes.
Therefore, my appointments have not been challenged in the writ petition at all. Next, 28 November 2022, in compliance with the order date 27, so passed, the West Bengal Board of Primary uploaded the breakup scores of the TET 2014 qualified independent candidate against so. But kindly pause for a moment here. Just wait. Pause for a moment. Since we are not parties in the writ petition, we could not able to take the point. The petition was not maintainable.
Yes.
If an illegality is in the trial, that cannot be cured in an appeal.
Yes.
In a case of a natural justice, I'll show judgment. Therefore, today, first point has to be decided whether that writ petition was entertainable.
Yes.
After having such a delay, and when the Justice Orijit Banerjee's judgment was there,
Hmm.
we
Yes.
don't go by emotion, we go by law. And law prevails over the equity. Law prevails over everything. Law is blind, one has to follow the law. No emotion, no perception, nothing. Whatever the law, one has to decide, we have to consider, decide the cases on the basis of the law.
Yes.
Next, Miller. In comparison with so-and-so, 12 May 2023, WP so-and-so was allowed by the learned single judge with an impugned judgment order without even considering the judgment dated 10th December 2019 and the judgment dated 23rd May delivered by the 23rd March. Also, a judgment was delivered before 12 May. Sorry, that was a judgment of Justice Hiranmoy Bhattacharya. I will show. Justice Hiranmoy Bhattacharya also dismissed a writ petition, batch of writ petitions. Point of argument as well.
Yes.
23rd, I will show to the lordships when I will cite the judgment. Therefore, before
I got it.
disposal of this writ petition, there are two coordinate bench judgments.
Hmm. Yes.
Next, my lord. My lord, directions of the judgment. By this time, your lordships know about what are the directions. I am not required to read. When I will read the judgments, I will read it. I am not wasting your lordships. I am trying to do it so quickly as that possible, my lord. Then, my lord, kindly come to page 11.
Hmm.
The appellants prefers a latest patent appeal before the Honorable High Court at Calcutta. That is, this is the appeal. So-and-so, and an application for leave to file a so-and-so, memo of appeal, so-and-so. 19 May 2023, the appeal court passed an order. This is the order, my lord. Appeal court passed an order. At page, your lordships will find 695 of volume 3. In this appeal, my lord got it, page 695, kindly see.
Yes.
695, my lord, big judgment. And kindly come to my lord, ordering portion. 715.
Hmm.
715. 1, 2, 3, 4 paragraph. Having heard the parties, the closely considering the materials placed, this court finds as follows. That admittedly the writ petitioner accrued a cause of action with the discovery of fresh materials placed by the board on 28 2022. As a consequence that the Honorable Single Bench was within jury to inquire into the aspects connected to the discovery of fresh materials. At the same time, the Honorable Single Judge had a duty to extend a right of hearing even in representative capacity to the present appointees, that is the appellants. This duty became manifest in the context of the appellants being protected from the loss of their job being the consequence of the decision rendered by two earlier concurrent honorable single benches of this court. This court intends to record the niceties of law relating to grant of natural justice, accrual right, delay and waiver, burden of proof, prisoner value of decision. They have a role to play in maintaining the system of adversarial litigation adopted by our courts unless hopelessly excluded. It is true that justice delayed is justice denied, and conversely, justice hurried is justice worried. To the mind of this court, therefore, the termination of job otherwise protected by two earlier orders of the Karno of so without extending a meaningful right of defense to the affected parties prima facie requires judicial intervention. At this stage, this court is also required to notice the proposition that the alleged complicity of the candidates in the commission of the alleged fraud rather deeper, leaving the issue thereafter to the court to strike down all fraudulent action. Accordingly, there shall be an interim stay on termination of jobs till the end of September 2023 or until further or whichever earlier. However, the board shall conduct the selection exercise exactly as directed by the Honorable Single Bench within a period of 3 months by and within the end of August 2023. The matter shall appear before the appropriate bench division in the first week of September 2023, subject to convenience. Therefore, my lord, this judgment, this order shows, prima facie, your lordships have been observed. We should have been given an opportunity of hearing by the learned single judge.
Yes.
And especially in view of the two coordinate benches judgment. Termination order was stayed, but the selection process. Against that order, we preferred the SLP. That SLP, your lordships was asking me, will kindly come to next page 718. It starts from 718.
Yes.
Kindly come, my lord, page 720. Permission to file special leave petition is granted. Issue notice. Notice is accepted by the respective respondents appearing on caveat. By consent of the parties, the instant petitions are heard and disposed of. These special leave petitions arise out on an order dated 19 May 2020, passed in Memeti number so and so, passed by the division bench of the Calcutta High Court, passed by the learned single judge in WPS so and so. The original writ petitioners have assailed the recruitment process of assistant teachers conducted by board in furtherance of West Bengal Board of Primary School so and so. The direction as spread before the learned single judge was against the concerned authorities to disclose the names, number, and category. All those candidates recruited till the date of filing of the writ petition in primary schools in the state. It was also prayed that the original writ petitioners be equally treated at par with those candidates who have already been recruited by the board, and they be granted the same benefits as extended to teachers already recruited in terms of the aforesaid rules. It was further prayed that they may be treated as par with non-trained candidates recruited by board after expiry of relaxation given by MHRD in the year 2015, and directions be issued to concerned authorities to issue the merit list maintaining transparency. It was this in this connection of the original writ petition before writ court that they were qualified in and despite having participated in the process election, they were denied appointment. Thus, claiming parity with the various other candidates who were appointed following the recruitment process, the aforesaid reliefs were paid for. The learned single judge video order is so and so, passed in so and so, directed by the council so and so. The order has been set out. Now, kindly come to page 723. Assailing the aforesaid order, the learned counsel for the appellant incumbent employee submitted before the writ appellate court that the directions as issued by the learned single judge are in gross violation of the principles of natural justice. Since the same has been passed without joining the affected person as a party in person or in representative capacity being a necessary party, and without affording opportunity of hearing to them as per the averments made in the writ petition, cogent allegations for establishing fraud in the selection process were not alleged. And in spite of that, the learned single judge directed for holding the fresh selection while cancelling the appointments of the more than 30,000 teachers, including the petitioner's hearing. The division bench of the High Court of Calcutta by the impugned interim order found that the termination of jobs as directed by the learned single judge prima facie required judicial intervention. The division bench granted interim stay on the termination of jobs till the end of September 2023 or until further orders, whichever is earlier. In the said interim order, it was observed by the division bench that considering the alleged complicity of the candidates in the commission of fraud in the process of selection which is contended surfaced during the pendency of the writ petition, it required deeper scrutiny in the scrutiny by the court. Therefore, the court also observed as under court. The court has directed to list the case before appropriate division bench in the first week of September 2023. Being agreed by the said direction, these special leave petitions have been filed. The primary contention advanced before this court is that the process of selection has been set at naught by learned single judge without joining the petitioners herein as parties to the proceedings and affording them an opportunity. It is further contended that having found force in the said contention, The order of termination was stayed by the division bench. However, it is contended that the conduct of fresh selection of more than 30,000 teachers in a time-bound manner has been continued despite foundation of fraud being not on record. Kindly mark it. Foundation of fraud being not on record in pleadings, and more so without affording any opportunity to the affected person to defend the case, which is in gross violation of the principle of justice. Sri Joydeep Gupta, learned senior counsel, appearing for the board while supporting the contention of the petitioner hearing, asked that the holding fresh interviews is a cumbersome and expensive exercise which cannot be possibly done as directed by an interim order. Interim order. On the other hand, learned counsel representing original writ petition defended the order of the learned single judge, containing that once the process of selection has been found at fault and the termination of petitioner has been stayed by interim order of the High Court, the continuation of fresh selection as arrived by the so-and-so writ court does not warrant interfere by them. Having heard learned counsel for the High at length, and considering the fact that the order impugned passed by the division bench is interim in measure, we refrain ourselves from expressing any opinion on the merit of the case. At present, we are prima facie impressed with the contention of the petitioner hearing that the order passed by the learned single judge was without joining them as party and without hearing them even in a representative capacity, though they were working since more than 5 years. The division bench video interim judgment order found weight in the contention, but only stayed the termination of service and did not stay the selection process, which was directed to be conducted following the cancellation of the appointment. We find this reasonable force in the submission made by the counsel for the petitioner that if the appeal which is sub judice before division bench succeeds, then the whole colossal task of conducting and continuing with the selection process will go absolutely in vain and lead to enormous financial burden on the board. Therefore, in view of the aforesaid, we set aside the impugned order of division bench to the context of the issuance of the direction to conduct the selection appraise. The said order is subject to final outcome of the orders in the matters pending at so and so. At the cost of the repetition, we further make it clear that we have not expressed any opinion so and so, so and so. Therefore, why set aside? We have not made parties. Today also I am saying, my lord, the learned single judge judgment should be set aside because we have not heard.
Yes.
But on 2 counts, I will say that this order is required to be struck down. This order is required to be struck down for not getting a chance of hearing for 2 reasons. One of the reasons we are not heard. Second most important reason is this. The learned single judge has relied upon the evidence of different witnesses. Did I get the opportunity to cross-examine them?
Yes.
I have not got the chance to cross-examine them. Firstly, if the matter was not to be heard without hearing the affected parties, is a right proposition of law. Is a right proposition of law. Then secondly, whether an evidence can be relied upon without giving me a chance to cross-examine them.
Yes, yes.
Therefore, both the 2 counts, this judgment is alone to be required to be set aside.
Yes.
Whether board has examined or not examined, what are the board's intention, board choice, I am not concerned about it. I have not got any sympathy from the board, rather petitioners have got sympathy before the learned single judge from the board itself.
Yes.
Not a single point has been raised before the single judge. At the very first day, when the petition was moved, board was supposed to take the point of the maintainability. Or board should have said that the appropriate, the persons who are affected, they should be made parties. At whose interest the board have not done it.
Yes. Yes.
I will show Millard one thing. I will come to the one of next I will show just judgments. But judgments. But one of the important judgment I want to show your lordships. Institute of Chartered Accountants.
Impugn orderটা প্লেস করবেন।
Institute of impugn order, I will place the impugn order after submission of my judgments.
That has been extensively placed, Mr. Bandyopadhyay.
Some points I will just, not that entire judgment, some points, somewhere, some places I just okay. This judgment was not there in the compilation. I have given the compilation. Bear me.
We are hearing you, Mr. Bandyopadhyay.
Huh?
We are hearing you, Mr.
No, just judgments are there. I have made it very short for, I know your lordships. The way your lordships works, my lord, I know. I have made it. Kindly come to me, lord, 1986, 4 SCC 537. Kindly come to me, lord, para 17 at page 552. Case is Institute of Chartered Accountants of India versus L.K. Ratna and others. Kindly come to me, lord, paragraph 17. First. Kindly come to paragraph 17. 17. It is then asked by the learned counsel for the appellant that the provision of an appeal under section 28A of the Act is a complete safeguard against any insufficiency in the original proceeding before the council, and it is not mandatory the member should be heard by the council before it proceeds to record its finding. Section 22A of the Act entails so and so, and no limitation has been imposed on so and so. Learned counsel appearing has in mind that view taken in some cases that an appeal provide. Learned counsel apparently has in mind that the view taken in the case that an appeal provides an adequate remedy for a defect in procedure during the original proceeding. Some of them cases, as mentioned by Sir William Waite's erudite and classic work on an administrative law 5th edition. But as the learned author observes, in principles there ought to be an observance of the natural justice equally in both stages. If natural justice is violated at the first stage, the right of appeal is not so much as a true right of appeal as a corrected initial hearing instead of fair trial followed by an appeal. The procedure is reduced to an unfair trial followed by the fair trial. And if the makes the observation, Major J in Leave National Union was Baker Builders, treating with another aspect of the point. If one aspect the contention that a defect of natural justice in the trial body can be cured by the presence of natural justice in the appellate body, this has a result of depriving the member of his right of appeal from the expelling body. If the rules and of law combines to give the member of the right to a fair trial and the right of appeal, why should he be told that he ought to be satisfied with an unjust trial and a fair appeal? Even if the appeal is treated as a hearing of de novo, the member is being stripped of his right to appeal to another body from the effective decision to expel him. I cannot think that natural justice is satisfied by a process whereby an unfair trial, though not resulted in a valid expulsion, will nevertheless have the effect of depriving member of his right of appeal when a valid decision to expel him is subsequently made. Such a deprivation would be powerful result to be achieved by what in law is a mere nullity, and it is no more triviality that might be justified on the ground that natural justice does not mean perfect justice. As a general rule, at all events, I hold that failure of natural justice in the trial body cannot be cured by a sufficiency of the natural justice in an appellate body. Therefore, today, if there is a violation of natural justice in the trial court, this judgment is needed to be set aside alone on that ground.
Yes.
Which is, if I had an unfair trial, if I have not heard it there, my lord, with great respect to your lordship, my lord, in an appeal court, your lordship cannot correct that. If it is sent back, a judgment comes, again I will get a forum of appeal. I cannot be deprived of a forum of appeal.
Yes.
And two important counts I have given. Not heard, not cross-examined. Not heard, not cross-examined. Now, my lord, take my compilation. Joseph ke dao. No, no, so all pages I will not read. Only few paragraphs.
এটাকে এটাকে কাটি আলাদা করে রেখে
Well, kindly come to me at page 1, first of the compilation. 2010, 12 SCC 204. Kindly come to paragraph 9 and 10. Page 4 and 5.
yes
Kindly come to paragraph 9. In case respondent 1 wanted her selection against the reserved category vacancy, the last selected candidate in that category was a necessary party, and without impeding her, the petition could not have been entertained by the High Court in view of the law laid down by nearly constitutional bench of this court in Udit Naran Singh so and so, wherein the court has explained the distinction between a necessary party, proper party, and pro forma party, and further held that if a person who is likely to suffer from the order of the court and has not been implemented as a party has a right to ignore the said order as it has been passed in violation of the principles of natural justice. More so provided also and so that they provide the non-joinder of nation party be fatal. Undoubtedly, provision of CPC are not applicable in this jurisdiction by virtue of the provision of section 141 CPC, but the principles enshrined therein are applicable. In Prabodh Bharma versus State of West Bengal and Tridip Kumar Dangal so and so, it has been held that if a person challenges the selection process, successful candidates or at least some of them are necessary parties.
yes
Then Miller next case, 2014 volume 16 SCC page 187.
para
187 paramiller 10, 11, 12, 13. Kindly come to page 7. এটাই তো
yes
মানে
on the same point
same proposition, but just this is now the last one. But kindly, I will not read paragraph page 11. Kindly mark paragraph 10. Paragraph 10 to 13. 10 to 13. Kindly mark it. Ten to 13.
13 to 2
I will just read paragraph 13, nothing more, 3 lines. In view of the aforesaid enunciation of law, we are disposed to think that in such a case, when all the appointees were not imputed, the writ petition was defective and no relief would have been granted. They were today by for your lordship division bench. Writ petition has been disposed of. Appeal your lordships are hearing. Today, your lordships will set aside the order and dismiss the writ petition. Because appointees are not been made parties.
yes
Now, I am switching on second point. The lordships will find from the note my page 13.2. Honorable single judge ignored the binding precedent of the coordinate bench. Lordships have seen that. Now I will show to you similar Justice Banerjee's judgment in this matter.
page 70
Page 70.
citation to
2019 SCC online Calcutta 4324. We are making so much research. The learned single judge should have also made so much research. iPad is given, SCC is given, will not check it up whether the High Court has passed a judgment or not. 2019 SCC online Calcutta 4324. Kindly come to Miller paragraph 14. See what have been dealt with by the Justice Banerjee. The petitioners have challenged the, my lord, got it? The petitioners have challenged the process of selection of candidates for appointment of the post of primary teacher in schools under different DPSs. If the petitioners succeed in establishing that there were incurable infirmity in the recruitment process, the entire process along with the panel of successful candidates prepared pursuant thereto will have to be set aside. I have given my anxious consideration to the rival contention advanced on behalf of the respective parties. I am unable to allow the writ petition for reasons more than one. Firstly, it is not in dispute that pursuant to the selection process that was initiated by issuance of notification date 2016, a panel of successful candidates was prepared and appointments have been given to a huge number of candidates in post of primary school teachers under different DPSs. If the petitioner prayer is allowed, the appointment of such candidates will have to be set aside. In other words, such candidates would be badly affected if an order is passed as paid for by the petitioners. This makes such candidates necessary parties to the instant writ application. Any person who may be adversely affected by an order which may be passed in a legal proceeding is a necessary party to such proceeding. Without hearing him, no effective order can be passed. An order passed without hearing necessary party is a nullity and has no binding effect. In this connection, one may be referred to the decision of the Swan. Similar, another Supreme Court judgment has been referred. Now, your lordships kindly come to paragraph 20. The petitioners contended that a large number of candidates were given appointments and it was practically impossible to include all of them as respondents in the writ petition. This is not acceptable explanation. The petitioner could have and should have included a few of the candidates who were appointed. In representative, Rule 12 of the rules governing the application on Article 20 of the Constitution framed by this court contemplates institution of a writ petition in the respective category of the framed by the court. A petition may be instituted a writ petition seeking to decide other persons also according to him would be similarly interested in the subject matter and result of the petition. Similarly, a petitioner may impede a person as a respondent in a representative capacity to represent the interest of others who may be similarly situated as the impeded as respondent. Further, Rule 53 of the state rules provide under the provision of the Code of the will apply to applications under Article 50 of the Constitution so far as the same can be made applicable. Order 1 rules of so and so for institution of suits and so and so are attracted to the writ petition for instance instituting a writ petition in a writ petition capacity. The petitioner needs to obtain leave of the court. No such prayer was made by the petitioner in the present case. Not such leave was obtained. Otherwise, a few of the appointed candidates have been included as respondents and not in a representative capacity but in their individual capacity. Hence, the writ petition must fall for non-joinder of necessary party. Secondly, the primary ground of the challenge of the selection process is the smaller kindly market. Rule 8 for the recruitment has been violated in preparing the panel of successful candidates. Apart from such body, no material prejudices have been found in support of such, nor any documentary evidence has been disclosed in support of such. Copies of the document enclosed to the writ do not inspire credence and in any way do not advance the case done by the petitioner. In that affidavit of a filed on behalf of the West Bengal Board, it has been explained as to how Rule 8 and so rules has been scrupulously adhered to and learned senior counsel appearing for the board has also explained the same to me in course of a submission. The petitioners wanted the court to direct the board to produce the entire record pertaining to the selection process. I was not and am not inclined to do so. The records are voluminous. It would be practically be impossible task for the court to delve into such records and ascertain as to whether or not the panel under challenge has been prepared, violating the recruitment rules. This would entail adjudication of a highly disputed question of fact, which the writ court is ill-equipped to do. What the learned judge has done.
Yes.
In this case, next 22. It is not in doubt that the High Court will exercise the power of judicial understanding can issue a writ of certiorari. This is paragraph 22, 23, 24. This is the judgment. I am not reading the entire thing to end. Next judgment. That is Lord Justice Hiranmoy Bhattacharya's judgment, page 77. Your lordships kindly come. Two different coordinate benches judgment. Milord, kindly do not mind, Milord. With respect, I will tell your lordships. From 2016, so many judges were there. They were sitting, Milord. Justice Mousumi Bhattacharya was sitting. Justice Banerjee was sitting. Justice Hiranmoy Bhattacharya is sitting. Other judges were sitting. Nowhere they have gone. Went to this court. Is it not forum shopping? Was it not a forum shopping?
Yes.
When you have felt convenience, then you have gone to that court particularly. Felt convenient. Then page 77. Felt convenient.
Yes. Yes, 77 on same lines it was.
No. This may stick, but on different grounds have been taken.
Paragraph.
Unfortunately, I have to say,
Paragraph.
the recently very Chief Justice of India has delivered a speech and said, it is unfortunate in our country, the sitting judge resigning and joining political party.
My lord, Mr. Banerjee, why we are going into these issues?
My lord.
Let us stick to the facts.
Yes. That is a part of that.
Please, Mr. Banerjee. Yes.
That is the forum stopping. Then, Miller, this is cited 2023 SCC online Calcutta 710.
Yes, we are on that judgment.
Kindly come to paragraph 9 to 24. You are saying, my lord, to me,
9 to 40.
9 to 24. If I give you one in see, Miller, page 17, paragraph 9. It is not in dispute. It is not in dispute that the selection process initiated with a notification of the